All right, everyone. Welcome to our Fast Case Work from Home Wednesday webinar. So today is one of my favorite sessions to do, which is known as the Supreme Court Roundtable. And why do I enjoy this webinar? Because it is the fun webinar. So what we're going to talk about today is I'm going to save everyone a lot of reading, and I'm going to spend the next 45 minutes to an hour discussing some of the most important Supreme Court cases of the 2020 term. Now, my name is Kent, and I am the West Coast reference attorney, and I am joined by one of my favorite law librarians and fellow Supreme Court fanatic, our head of outreach and senior law librarian, Erin Page. Now, before we get started, hi, sorry to talk over you there. But before we get started, as always, let's talk about a little bit of housekeeping. So this webinar, while informative, definitely informative, is not approved for CLE credit. If you do need CLE credit, I'm happy to say that we do provide up to 4 hours of free CLE credit by going to fastcase.com/webinars to register. We offer a rotating library. Each session is 1 hour of CLE credit each, and they are offered every Thursday at 1 p.m. Eastern Standard Time. Number 2 for housekeeping is that all of the slides, all of the cases we reference and the associated slides will be sent out to you in a follow-up email. Bear with us. It may take a day or two for you to get this in your inbox. We'll also include a recording of the session in the event you have to leave early or you know someone who might be interested in it. Now, with housekeeping out of the way, Erin, would you like to engage in a shameless plug about some of our previous webinars that people should check out?
Absolutely. So I do want to mention that this is not the first time that we have discussed Supreme Court related cases as a part of our webinars. We actually have 2 specific sessions that we'd like to recommend to your attention. The first one we did at the end of June, and this was our first Leaders in Law episode. This was episode 1, The Legacy of Lawrence v. Texas. Now, we recommend this one for your attention, not just because we discussed Lawrence v. Texas, which is, of course, the famous Supreme Court case, but we also discussed a number of more recent decisions, including one of the cases we'll be touching on today, Bostock. So I do recommend going back and listening to that particular webinar if you have not had a chance to do so. It was absolutely fantastic. Some of the best legal minds involved in the LGBT movement and the decriminalization of all of those issues. So I really, really recommend that webinar to your attention. And the link for it, as you can see, is on screen right now and will be available to you via the follow-up email we'll send from today's session. The second webinar I want to recommend to your attention was our Work from Home Wednesday from last week. Titled Copyright of the Annotated, the Fast Case CEO discusses Georgia versus publicresource.org, which is, of course, one of the decisions from this term as well. We're not going to be touching on this case during today's session because our CEO, Ed Walters, spent literally an entire webinar session on that one case. So instead of trying to do a short form version of it today, we're just going to recommend that you go back and listen to that session as well. It was truly excellent. Went through all of the different copyright and government produced document theories and all of the fun information that you'd ever want to know about that particular case. So I do, again, commend that one to your attention as well. All righty, turning it back over to you, Ken.
All right, if you'll flip that slide for me. So the first real major area we see in Supreme Court jurisprudence that I would consider to be kind of one of the integral changes is really the defining of what it means for both intermediate scrutiny and also the defining of an undue burden as it concerns the right to abortion, but also contraceptive services generally. So first, we're going to talk about June Medical Services versus Russo. I've placed a public link for you, so when you get this slide, if you click that link, it's going to take you directly to the case so you can explore the full version. Erin, if you will, flip me to the next slide, please. All right, so what happened generally in the June versus Russo case? So Louisiana essentially had on the books that if a abortion provider wanted to perform abortions within the state, before anything else, they had already had statutes that basically said that if you were an abortion provider, you had to be registered to perform surgery at a hospital anywhere in the state, or you had to have some sort of agreement with a emergency room or a surgery specialist in the event that something went wrong with your abortions that you were performing in an outside clinic. Now, what happened is Louisiana decided to go a little bit further. So they had passed Act 620. So what Act 620 did is it took this standard of being any hospital within the state, you need to have the right to perform surgery or have a transfer agreement in the event that something went wrong. So this expanded it and it went beyond and said that we're now going to require any doctor who performs abortions to hold active admitting privileges at a hospital, but they implemented a geographical restriction. So all of a sudden it went from hospital anywhere in the state or with a transfer agreement to you had to have admitting privileges located not further than 30 miles where your abortion clinic was located. Now it defined these admitting privileges in an interesting way. It didn't only say that you had to be able to perform these surgeries successfully at a hospital within 30 miles. It went further to say that you also had to be a member in good standing. Now, what this meant was you had to maintain credentials that gave you the ability to admit a patient, to provide diagnostic and surgical services to a patient at any time. Now, 5 abortion clinics and 4 abortion providers decided to challenge Act 620 before the date it became effective. They essentially alleged that it was unconstitutional because it imposed an undue burden on the right of their patients to obtain an abortion. Now, what was going to be the result of this geographical restriction is that Louisiana, at the time Act 620 was passed, only had they had 5 active providers and 1 backup. So the Supreme Court generally said that this act did not pass constitutional muster because it placed a substantial undue burden. Because the end result was we were going to go from 5 providers with 1 backup to a single providing physician in the entire state. If you will, Aaron, will you flip me to the next slide? So what was the test that the court used? Now, if we look over the jurisprudence for what has in the past has constituted a substantial or an undue burden, the issue with the case law, especially because it's often been sort of differing between circuits. So if you were in the 6th Circuit, they would provide more weight to expert opinions, versus in the 8th Circuit, they provided more weight to legislative fact-finding. Well, this case decided to really clarify the tests that we use when we're determining whether something is an undue burden in the specific context of the right to an abortion. So the court said a statute which, while furthering a valid state interest, has the effect of placing a substantial obstacle in the path of a woman's choice cannot be considered a permissible means of serving its legitimate ends. They point out things like an undue burden will have the purpose or effect of presenting a substantial obstacle to a woman seeking an abortion. They also remind us that in direct opposition to the 8th Circuit, that we must review legislative fact-finding with deference, but we cannot, as you see in 8th Circuit cases, we cannot make this state-provided interest depositive. So it's not enough to say, as we've seen in 8th Circuit cases, it's not enough that the state is saying, I'm doing this restriction in order to protect the health of a person seeking an abortion. Because previously it was almost like there was this sort of per se assertion when we're dealing with a state interest. So with all of this sort of discussion, we end up with this test that you see on your screen here. So first, we want to determine the weight that we give to the stated benefits by the state actor. Now, as I was telling you before, the proper weight that we give to legislative fact-finding or to evidence proffered by the state. So typically we're looking at, in this case, we were looking at things like legislative history. So they're providing things like witness statements and hearings from around Act 620 and things of that nature. And the court made sure to clarify that we're giving it deference. So what does it mean to say that we're giving it deference, but we're not making it dispositive? What this means is that we are no longer saying that the interest claimed by a state creates a rebuttable presumption. In other words, what was happening in all of these court cases was it was almost like the state was saying, this is the interest, and we were really examining it under sort of a rational basis standard, under a very loose standard where almost every restriction was being upheld as valid or constitutional. The court essentially said that no, what we want to actually do is we want to examine it under a heightened standard, under intermediate scrutiny. So we want to once more consider all of the evidence, but also make sure that everything is backed up by proper evidence. Now, the next thing you want to do is you want to determine the burdens that are being imposed by to the seekers of abortion. But also, this was the first time that the Supreme Court also explicitly pointed out that when we're dealing with a burden, we also want to focus on the burden to the abortion provider itself. So we also want to focus on not necessarily just on how far a person seeking an abortion has to drive or how much money they're expending in order to actually make it to an abortion provider. We also want to look at, does a restriction we're placing on, or does the state interest result in financial burden to the provider? Does it result in the inability of the provider itself to actually be able to perform all of the abortions that are regularly sought in a specific area? And then, of course, the third step we're going to do is we're going to balance burden against benefit. Now, as I was saying before, we're no longer going to engage in this really loose standard. We're going to really focus on something that is more of an intermediate scrutiny standard. So the state benefit should be neutral. It should not be rooted in religion or morality considerations. And it should not, as I was saying, for the first time, it should also not result in excessive travel or financial expenditure from those seeking abortions. Now, when I was looking at this case, I also went back and examined some of the trends that are happening when we're doing these kind of examinations. And so what you really see is that when you're dealing with a 40% or more reduction in provider location, so if a state has an interest that is resulting in abortion providers or abortion clinics shutting down, we really want to focus on the percentage of the providers that are shutting down. Now, another interesting area that people focus on when they're really wanting to determine the sort of level of burden is they also are now focusing on wait time. So are you a person seeking an abortion and you go to the clinic that is closest to you and you end up having to come back the next day, or you end up having to go and you have to wait for 8 hours, or you end up having to go and there's a 24-hour delay, things of that nature, some of the common ways that we see regulations being placed on abortion. Now, the other area that we see, and so for that sort of increase in wait time, the percentages fall somewhere around a 50 to 60% increase in wait time for a person seeking an abortion is likely to result in the state action being considered an undue burden. Now, another interesting area that I've touched on a few times is that lower courts are also expressing an increasing willingness to consider things like travel time, and indirect costs. So as I noted before, if we pass the state action and it looks like the state action is going to shut down the clinics in your area and you're having to drive, some of the cases reference, an undue burden would be, I have to drive 10 hours round trip in order to seek an abortion. Or the state has said that there's a 24-hour waiting period. So I have to drive 10 hours and then I have to pay for a hotel, things of that nature. All right, Erin, if you will, next slide for me. All right, so what was the claimed benefit? In this case, Louisiana had claimed that the benefit of the credentialing was to ensure that abortion seekers were only having abortions performed by physicians who are maintaining the highest level of proficiency when performing surgery. In other words, their logic, or their claim logic was this, was that if I ensure that physicians who are performing abortions are also regularly performing surgeries in hospitals, I can guarantee that there's this high level of competence with surgery generally, such that we don't have any concerns. Now, the court said that this benefit failed for multiple reasons. Number one, the court said that the state introduced no evidence showing that patients have better outcomes when their physicians have admitting privileges. So this is really important. This first piece is really important because, as I told you before, the standard of examination of the state interest has been heightened. It is no longer enough for a state to simply say, this is my interest, this is what the drafters of the act intended it to be, and that is it. That would be what we consider to be almost a rational basis type standard. In this event, we're looking at, okay, well, not only do they have to say what their interest is, they also have to back it up by data, which is really the first of its kind, where you have the Supreme Court really emphasizing that point in the examination of what is considered an undue burden. Now, some of the other reasons why the benefit did not pass muster is that the act had, as I noted, a 30-mile requirement. This was in direct sort of opposition to the standard protocol for any patient experiencing a complication generally when they're working with an outside physician. The state mandated practice, now this was a practice mandated by statute, which made it really interesting, was that if you have a problem with, let's say, an outside physician in a clinic generally, is to send the patient experiencing an issue to the hospital that is closest to where the patient lives, which is not any way, shape, or form related to 30 miles of the clinic where abortions are being performed. Now, they also looked at evidence that show that complications from surgical abortions are relatively rare. And also, another interesting piece of evidence was the fact that 50% of abortions in Louisiana were being performed without surgery. So they were being performed with solely medication. And then the most important imperative piece of evidence was that the state's admitting privileges expert testified that a physician was competent to perform surgical abortions without at any time needing to be accredited with a local hospital. He said as long as a physician had completed any accredited residency in gynecology and had been trained in abortion procedures generally, no issues had arisen to his knowledge. This was really the state expert. All right, next slide for me, if you will. Now, the big thing was the fact that the burden, as I was mentioning before, the burden was extreme because the credentialing standard was going to remove every single physician except for two. Now, don't get too excited when I say it, because you might have remembered I said that previously it was one. Well, what had happened was it was going to go from 5 in a backup to 1, but they were going to be in opposite areas of the state. So the one that was in the north portion of Louisiana said, no, there's no way I can keep up with the demand. So he was going to quit. And so as a result, you were going to have a single provider performing 10,000 plus, or being requested to perform 10,000 plus surgeries a year. Now, what the evidence was also showing was that there were moral and religious considerations at issue, that the hospitals where these physicians, so the district court did something really interesting in this case. The district court said, when I'm engaging in my fact finding, I'm going to follow around these physicians for 18 months and really examine, their efforts at attempting to get admitted. I'm going to look at what is the process. What they realized was that even though half of the physicians had 20 to 45 years of experience each, they were being denied entry into local hospitals based upon religious exemption. So the hospitals were basically saying, we do not want to be associated with anyone who performs an abortion. What was happening was in places like Baton Rouge, anytime there was a known abortion provider that sought to be admitted for the purposes of acquiring these credentials, massive protests were erupting. So the hospitals were basically saying, we understand what the act is going to do, but based upon sort of public reaction and also our own religious beliefs, we're not actually going to allow you, even when you apply and you're otherwise qualified, we're not actually going to allow you to be a recipient of these credentials. Now, the other interesting part was that you had to maintain your credentials. This meant that if you were an outside physician, you had to have admitted into the hospital 5 times or more a year a person, so one of your patients. So if you were let's say an outside clinic provider who was simply performing abortions using medications, it almost seemed like the logic, and this is what physician number 3 was saying, often referred to as DO number 3, was saying, do I actually need to go out and injure my patients? Because to physician number 3, the logic was, well, the fact that my patients are not having problems that are severe enough to end up in the hospital should tell you that I am a good physician. In fact, a more qualified physician than a person who may have those issues of 5 or more problems in a calendar year necessary to maintain your surgical credentials. So next slide for me, if you will. So this is a map of what the providers look like, or would have looked like before 620. So you see that we have the 5 and the backup performing somewhere between 7,000 and 10,000 procedures a year. And then if you'll do the next slide for me. This is what it was going to look like after. So you are going to, and by the way, DO number 3, so physician number 3 was the one that said, I cannot do this, I am going to resign. That would have left physician number 5, who you see as of right now, is only able to perform about 3,000 procedures a year, despite there being a demand of 10,000 on average a year. So the data based upon the best example showed that physician number 5 said, okay, well, I can probably do a 30% increase to what I'm already doing, but that still stood to leave about 6,000 people without access to procedures. And even those who were able to get to physician number 5, if you have ever driven that distance between the north and the south of Louisiana, it takes you about 10 to 12 hours round trip. All right. So let's move to the next slide for me. So some other things that Russo did outside of the obvious expanding of the definition of how we examine an undue or substantial burden. It also clarified standing. So the court explicitly provided that abortion providers held the right of third-party standing to assert violations of a constitutional right to an abortion on behalf of their patients. Now, the court's reasoning was that the court said in any event, the rule the state invokes is hardly absolute. So the states were saying, no, this doesn't make any sense. They should not be allowed to have third-party standing. The court said, we have long permitted abortion providers to invoke the rights of their actual or potential patients because we have permitted plaintiffs to assert third-party rights where the enforcement of the challenge restriction against the litigant, so this is the test, would result indirectly in the violation of third parties' rights. So in other words, if they passed Act 620, it was going to make the abortion providers virtually impossible to do their job, and as a result, interfere indirectly with the ability of people to seek abortions. Or in the event that they sought an abortion, the ability of them to seek one with ease. So moving on to the next slide for me. So some other things was we also end up with one of my sort of favorite side benefits, a clarification on appellate review of trial court fact-finding. So the court said a number of things. They said that finding of facts by a trial court are upheld unless clearly erroneous. They said that when we're dealing with a review of a trial court fact-finding, that we do not review it de novo. And then finally, and the most impactful, and this really took us in a new direction, is the appellate court is not to reweigh the evidence in a different way than the trial court did. So if the trial court said, okay, we're giving a lot of weight to the expert opinion, as the trial court did in this case, it's not up to the appellate court to say, no, 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 I didn't find that as convincing. Because what had happened in the appellate court here was that the appellate judge had said, I don't think that I am going to give as much credence or as much favorability to the attempts of the physicians to actually acquire the credentials. So the appellate judge was essentially reweighing the evidence, and the Supreme Court said, no, no, no. When we're dealing with trial court fact finding, what the trial court is doing, as long as it's not clearly erroneous, it stays. And the other interesting part is they also explicitly say that you cannot even rejudge the credibility of a witness. And when we're dealing with cases like these, expert witnesses are often imperative. So as we saw with the trial court here, the trial court gave a lot of weight to the fact that the state's leader of the credentialing process said, there's not really any evidence that shows that one needs to be credentialed in order to perform abortions in outside clinics successfully. All right, moving on to the next one. All right, so the last sort of side point that we get is the fact that Russo is another example of the sort of current Supreme Court's terms focus on what weight do we give legislative history. And if you're like myself, I adore legislative history. But in just the current term alone, 15 cases from just the current term of the Supreme Court have referenced legislative history. Now, 7 cases have used it positively, 8 have used it negatively. Now, it's been used 4 times in majority opinions. It's been used 11 times in dissent. Now, the general trend is to diminish the role of legislative history generally as a tool of reference in Supreme Court jurisprudence. In fact, the only time that I have seen a case even care about legislative history is for the sole purpose of defining an ambiguous term when looking at a matter of statutory construction. They do not give legislative history a lot of weight when we're determining constitutionality of a state or federal statute. Right, next slide for me. So now, let's talk about 2 other cases that involve a common theme of the role of morality. So when does a religious exemption to something turn into a potential moral excuse? So the first case we have Little Sisters of the Poor versus Pennsylvania. I've placed a link here for you. We can go ahead and move on to the next slide. So the basics of this case was that the 2010 Affordable Care Act required employers to provide women with preventative care and screenings without cost share requirements. Now, the caveat was that this was done pursuant to guidelines as provided for. So I want you to make sure you focus on the language because it's going to be important later. As provided for by the Health Resources and Services Administration. Well, HRSA and subsequent litigation ended up allowing employers with no disclosure to the federal government to not provide access to contraceptive or contraceptive services, such as abortion or abortion counseling, if it violated the closely held religious or moral beliefs. Now, the state of Pennsylvania ended up challenging the guidelines. They argued that the Affordable Care Act authorized the HRSA to define the types of contraceptive services the employer must provide, but did not give the HSRA the ability to create categories of exemptions, such as it did for any business with religious or moral objections to the providing of said contraceptive services. Move to the next slide for me. Slide before that, sorry. So the majority, and this was authored by Justice Thomas, so this may be, nothing surprising to you, but citing to nothing more than numerous dictionaries, and I wish that I was joking. They cited to nothing more than numerous dictionaries, held the following, that because provide means to supply, furnish, or make available, and because the word as function as an adverb modifying provided, which indicates the manner in which something is done. The court held that based solely upon this, that the provision at issue grants the HRCA with unbridled, and this is important, unbridled discretion to make determinations, including the ability to identify and create exemptions from its own guidelines. Now, the court further ruled that had Congress intended to place limitations on the HRSA's power, it would have done so explicitly. The court wrote that Congress could have limited HRSA's discretion in any number of ways, but it chose to not do so. Instead, it enacted expansive language, offering no indication whatever that the statute limits what HRSA can designate as preventative care and screenings, or who must provide that coverage. Moving on to the next one for me. Now, after the holding, Justice Thomas does something even more interesting. He goes into dicta about the Religious Freedom Restoration Act. So next slide for me. So what is the RFRA? I often get these letters kind of jumbled. So what this does is it essentially says that government cannot substantially burden your exercise of religion, even if the burden results from a rule of general applicability. Now, you can get around this by showing that you're furthering a compelling government interest. That is done with the least restrictive means. Now, what happened, though, is the RFRA has been expanded to show that you actually don't have to show that your religious or your violated exercise of religion corresponds with, and I have this in bold, corresponds with a recognized system of religious belief, which is how we end up in the land where moral conviction and religious objection have essentially been muddled. Now, they have been so muddled that in the 2014 Burrell case, the court has even stated in that case that separating moral convictions from religious beliefs would be of questionable legitimacy. So the question we're left with now is, how far can one sort of exempt themselves from federal government oversight based upon a simple moral objection? Move on to the next slide for me. So this is where Bostock comes in. So Bostock comes in because it essentially says, so at the end of the last case, and in the dicta around RFRA, the judge essentially said that even if the clear language of the ACA, or frankly, the clear language of the ACA plus the dictionaries that we referenced, had not provided a remedy, they would have still likely been able to be exempted based upon the RFRA. Now, in Bostock, got the link here on the screen for you, we have another example of a case that is talking about one issue, but may have some darker consequences. So the darker consequence from this case may be, can moral opposition via the RFRA be extended to any area of the law? And in this event, does this case actually license sex discrimination? So if you're not familiar with this case, let's get familiar. If you will, next slide for me. All right, so the premise of Bostock was quite simple. The premise of Bostock was Title VII's prohibition on sex discrimination covers gay or transgender persons. So in this case, we had 3 employers that had each fired a longtime employee for being homosexual or transgender. Now, each employee sued, and they alleged sex discrimination under Title VII of the Civil Rights Act of 1964. Now, this makes it unlawful for an employer to fail or refuse to hire or to discharge any individual because of such individual's sex. Now, the 11th Circuit held that this suit could be dismissed. They said that sex discrimination clearly does not cover gay or transgender people. Now, the 2nd and 6th Circuit said, we disagree, and we're going to allow these claims to proceed. The Supreme Court ultimately ruled in favor of the employees. Now, in doing so, they ruled as such. They said that an employer violates Title VII when it intentionally fires an individual employee based in part. Now, in part is crucial. It doesn't have to be in totality, in part on sex. It makes no difference if other factors besides the plaintiff's sex contributed to the decision, or that the employer treated women as a group the same when compared to men as a group. So essentially what they were saying was, well, we treat all gay people the same way, and we treat all transgender people the same way, regardless of sex, so how are we discriminating? The court said that did not matter. A statutory violation occurs if an employer intentionally relies in part on an individual's sex when deciding to discharge the employee. They finished by saying, because discrimination on the basis of homosexuality or transgender status requires an employer to intentionally treat individual employees differently because of sex, they violate Title VII. There is no escaping the role intent plays. Just as sex is necessarily a but-for cause when an employer discriminates against homosexual or transgender employees, an employer who discriminates on these grounds inescapably intends to rely on sex in its decision-making. So in other words, the logic was, okay, well, if I fire you because you are a man who dates a man, then I'm engaging in sex discrimination because I would not fire a man who dates a woman. That was the kind of rigidity of the opinion, which is how we end up in a weird land. Next slide for me. So we had an interesting issue involving Harvard. So Harvard had essentially said that an interesting consequence had resulted from the opinion. So Harvard University had a social policy basically that said, we do not want to encourage fraternities or sororities or any type of organization that was really single sex based or single gender based. So what they did is they said, if you choose to be a member of these organizations, we're going to ban you from leadership positions. We're also going to ban you from fellowships, such as the Rhodes and Marshall scholarships. Now, Harvard got sued by fraternities and sororities because, in large part, the exclusion from these fellowships. Now, they ultimately decided to stop fighting this case based upon the decision in Bostock, because they said that because Gorsuch, the author of the Bostock opinion, was too mathematical. They said he failed to discuss systems of equality generally, but more so did what appeared to be simply rigid mathematical calculations. So what they were saying was, they essentially said that he adopted this view. So in his view, the Civil Rights Act can be understood to adopt the rule that an employer may not treat XY different from XX. When an employer fires an employee for being gay, the employer is in effect declaring that XY and XY does not equal XY and XX. The employer thus treats XY and XX differently and thereby violates the statute. So Harvard's logic was, we are prohibiting a group consisting of XY, 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 but not of a group consisting of XY, XY, XX. So what they were saying was, we cannot continue to challenge this rule because it is under the Bostock opinion, if you don't allow a male to join an all-male fraternity, but you allow a female to join an all-male fraternity and vice versa, that is still sex discrimination. Harvard initially thought that, well, we treat everybody the same based upon these rules, but as we learned earlier from Bostock, it does not matter. If we treat entire categories of people the same, what we focus on is the individual treatment based on sex. The next slide, if you will. And interestingly enough, before the Bostock opinion, the one judge actually agreed with this logic. So a district judge had previously denied Harvard a motion to dismiss on the very point made concerning Gorsuch's rigidity. They said this: it is impossible for Harvard to apply its final rule without considering both the sex of the particular student and the sex of the other students with whom he or she seeks to associate. Whereas a male student seeking to join an all-male organization would be subject to the policy, and vice versa, a female student seeking to join the same all-male organization would not be subject to the policy. They concluded by saying the fact that the female student would otherwise not be allowed to join the all-male organization because of the organization's own discriminatory policy does not alter the conclusion that the sex of the student is a substantial motivating factor behind the policy. So this ends up with, we are now in the very interesting land of Gorsuch or the opinion written by Gorsuch with Bostock seemed to be quite heartening, but did it otherwise license one other type of sex discrimination? According to Harvard, it did just that. All right, so moving to the last slide, because I'm heading over and I need to turn this over to Erin. So the last consideration is, does Bostock promote morality exemptions from sex discrimination under the RFRA? So Gorsuch referenced the RFRA in passing and said the following. He said, Congress has gone a step further with the Religious Freedom Restoration Act. It said that the statute prohibits the federal government from substantially burdening a person's exercise of religion unless it demonstrates that doing so furthers a compelling government interest and represents the least restrictive means of furthering that interest. However, he went further to say, the RFRA operates as a kind of super statute, displacing the normal operation of other federal laws and may supersede Title VII's commands in appropriate places. This has led to the concern of, could an employer, based upon these morality exemptions under the RFRA, which, as I was saying before, have been since that Hobby Lobby 2014 case, widely interpreted, could it allow them to say, I am sort of exempted from engaging in sex discrimination as it protects gay and transgender persons based upon a moral objection? He did not answer that question, but that is where we are left. All right, Erin, your turn. Sorry for going over.
All righty, so I have 3 different cases. First one we're going to take a look at today is McGirt versus Oklahoma. And in contrast to the cases we've discussed so far, this one has no religious or very few religious implications. McGirt versus Oklahoma dealt with a defendant who was being prosecuted for some rather indecent activities. But the general concept or the reason why this particular case went to the Supreme Court and the implications of the decision of the Supreme Court are supremely wide-ranging for this particular case. So the issue at hand is, of course, was Jim C. McGirt prosecuted by the correct sovereign? So in the original case, and through all of the appeals following, the case was dealt with by the state government of Oklahoma. The crime in question took place within a territory of land, however, that is known or was known to be a Native American reservation. Specifically, this particular reservation was set up for the Muscogee or Creek Indian tribes or Native American tribes. The map that you're seeing on the screen right now, this is actually one of the historical maps from 1890 showing the original boundaries and designated reservations for the tribes that were moved west. Most of them moved west as a part of the Trail of Tears project or catastrophe, depending on how you're looking at it. Now, the Muscogee or Creek Reservation area. This is actually a very well-known area of Oklahoma. It is, in fact, the area surrounding Tulsa. So very large area, very well populated, and a very important question because the original treaties involved and the language of those treaties is what is going to, or what made the determination as to which sovereign should have prosecuted Mr. McGirt for this particular issue. I'm just giving you a little bit more of a context for what we're talking about here. Again, just showing you the land and the area that is at question. So originally, the entire area, including the Badlands area of Oklahoma, was considered to be a completely separate and independent nation. At the time referred to as the Indian Nation, and the treaties that were involved, each one for each tribe separately, no Universal Unifying Treaty, which might have actually fixed this particular problem. But each of the treaties involved had slightly different language and had slightly different promises being made on behalf of the tribe in question. The language involved with the treaty for the Creek Muscogee tribes specifically stated that in exchange for relinquishing their area and their territory in the southeastern portion of the United States, mostly in the Alabama and Mississippi areas, but there were other portions of land as well. In exchange for relinquishing those areas, they would be granted the territory in Oklahoma. And the treaty specifically stated that this treaty was, or this land was to be granted to the tribe with, and the tribe would have the right to pass its own laws, police its own people, except to the extent that the federal government chose to impose laws upon that particular tribe. So the very interesting treaty by itself, but the issue at hand in the trial itself was who had the sovereignty, who had the right to prosecute McGirt. And this is because since this treaty, as is usually the case with many treaties that we're involved with from that era, the federal government has changed, modified, or otherwise not maintained the obligations that were dealt with in that particular treaty. In this example, the federal government has not exercised the right to police or prosecute any tribal members that have been caught or have been accused of crimes in that particular area. Now, do keep in mind that these laws or these rule regulations under the treaties apply only to members of the tribe, so only to those who have been recognized as members of the tribe as a part of that particular nation. And as well to any crimes that are perpetrated by a member of a tribe against the citizens of the United States or against non-tribal members as well. So even though the United States has not exercised those rights or those rules, the question was, is that the in fact controlling law for this member of the tribe? Now, this is kind of an interesting question. Again, there's been other tribes, other treatises, actually close to 500 of them that are still in effect or that could still be in effect to this date. And of course, many, many responsibilities, many different arrangements that have been made as a part of all of those treaties. As to what the court actually found, the court did acknowledge that the treaty was originally a treaty. Always an important first step. They acknowledged that it did in fact create a reservation, and they stated that once the reservation was established, there had not been an official disestablishment or diminution of the treaty. So even though there were a number of acts that the state of Oklahoma and other entities, Amici, had pointed to saying that the Congress had evinced an intent to diminish or to disestablish the reservation, Congress had never actually taken the step to formally do so. So they had never actually disestablished the reservation, and therefore all of the rules and regulations pertaining to it under the treaties still applied. So again, there's kind of a formality issue here. Congress has behaved as if they have disestablished the reservation, but they have not actually said that they have done so. This has got very, very wide-ranging impacts for a number of reasons. The first one, of course, being that in the interim, since the federal government has ceased to obtain or maintain these rights until today, anyone who is a tribal member who is prosecuted for these major crimes under the state law instead of by the federal government directly is possibly incorrectly or has been prosecuted by the wrong sovereign, which means that there are a number of cases that now are in a situation where there is no rightful sentencing, no rightful conviction, and quite a bit of possibility that there's double jeopardy issues attached. So there's direct impact of this particular finding for people who are under these treaties agreements in Oklahoma. However, there are also further ranging implications from this decision, including since the obligations under the treaties as regarding crime have been established. There are also obligations under these treaties regarding the treatment of the land, the ability to negotiate for rights and responsibilities, and environmental and land property rights that have also been established under these treaties that will also be impacted by this decision that the treaty is still in good standing. So this means that there will likely be massive impacts on environmental causes in the area, including fracking and other oil-related industry, water-related industries, and fish and wildlife-related activities. And it's also kind of an interesting finding as regards the treaty obligations of the United States generally. So this finding that without a formal disestablishment or a formal diminution of a treaty, that the treaty itself is in good standing and that all obligations under that treaty are also required to continue, has a huge impact on other treaties that the United States has entered into over the course of its existence, and will be very interesting for future negotiations, to say the least. And just as a reminder, you're welcome to ask questions at any point during today's presentation. That questions button on the GoToWebinar pop-up will allow you to enter questions. Second case I wanted to go over quickly is CELA versus CFPB. And this case, I do recommend it for your reading on your own time, just because it has so many interesting twists and turns. But the major question for this particular case was, can a regulatory body which has significant delegated legislative roles be headed by a person who can only be terminated for cause or can be terminated at will? So just unpacking that just a little bit, the CFPB or Consumer Financial Protection Bureau, was established as a part of the Dodd-Frank regulations and legislation that was enacted right after our most recent financial crisis. Not a terribly popular set of legislation, but one that had far-ranging impacts. And the CFPB has a number of duties that have been specifically delegated to it, as well as a lot of flexible power that was just delegated more generally speaking to the Bureau. So among other things that the CFPB is regulating and is proceeding to indictment or prosecutions on is the actual regulation and prosecution of people who have been flouting various rules that were established for the protection of consumers. So this includes debt collection practices and acts, and that type of action was what led to the plaintiffs in this particular suit. The CELA law firm, which was involved in various debt collection actions, received a request an investigative subpoena regarding some of the information that they had as a part of their firm regarding their debt collection practices. Again, they were thought to be in violation of some of those provisions of the law. Now, the technical question here is an interesting one. CELA law did not, or at least in this portion of their lawsuit, was not contesting the actual subpoena that was delivered to them, but rather whether the entity in question was established properly, whether an entity like that could be established with a leadership or with the head of that particular entity being one who had both legislative and executive and semi-judicial responsibilities. So essentially, whether a particular entity could have all of that power concentrated in one person who could then only be fired for certain types of cause and not at the will of the executive. So this is the common format that's currently taking place for entities of this type. The CFPB is most certainly not the only example of this type of executive body. Current examples, the Securities and Exchange Commission, the Federal Trade Commission, the there's all of the famous examples that you can imagine off the top of your head. They are all examples of commissions with this type of multi-area, multi-responsibility entity. However, the format that most of these regulatory bodies have is to have their leadership role spread across a number of commissioners, usually 5, 6, or 7 commissioners involved. And the enacting legislation usually requires that this mandatory number of members have a certain number of members per political party, usually an even split or an almost even split, and then also requires a certain number of those commissioners to be uh, present or available for a quorum to be met for that particular body. And that leads to the actual problem with having a committee or multiple parties involved. So this is the current panel of commissioners for the Federal Election Commission, so the FEC. And the statutory language for this particular committee regulates that there have to be at least 4 members of the committee present in order for there to be a quorum, in order for certain actions to take place, including the regulation and suggestions that they make to election commissions to avoid things like foreign influence and other election violations. The Federal Election Commission has already spent this calendar year with of 9 months, 9 months out of this last calendar year, lacking a quorum. So that meant that they could not, in fact, do any of their regulatory duties, that these almost 1,000 regulatory actions that they would otherwise have investigated and prosecuted have not done so because they were simply unable to act without a quorum, which would have been that 4th seat. The 4th seat actually did exist for about a period of about a month and a week or so. And then one of the commissioners resigned, taking us back to 3 commissioners, and again, under the quorum requirements. So very tricky to make sure that these types of bodies maintain their quorum in the current political environment, and was probably the inspiration for having a single commissioner as the head of the CFPB. So what did the court actually find for this particular case? The court very emphatically declined to extend the rationale that justified or that permitted having the committee style where there were multiple members involved and where some of those members could in fact be dismissed at the will of the executive. The court declined to extend that permission or that capability to a single commissioner style of framework. Essentially, the argument was the historical one, saying that there was no previous precedent for having a single commissioner, with the exemption of a couple of examples that happened temporarily during wartime periods, and that they simply did not think that it was constitutional to have such concentration of multiple branch powers within a single person, and then furthermore to restrict that person from being fired for situations that were not just for cause. So the CFPB itself and the greater Dodd-Frank Act were severed from that particular clause, and that particular clause was found to be unconstitutional. And I know we are well over time, but I do want to commend to your attention Chiafalo et al. Versus Washington State. This and its sister case involved the faithless electors issue. So the major question for this particular case is, can a state impose a sanction on a federal elector for failing to vote in alignment with the popular vote of the jurisdiction that they are representing? So, of course, the Electoral College is a part of the Constitution and has been modified by the Bill of Rights. It was, in fact, a historical set up. Historically speaking, there have in fact been faithless electors or people who have chosen to vote against the popular vote that they were supposed to from the very first presidential election back in 1796. However, even though it's got a long history of existing, it's also a very small issue. Less than 1% of Electoral College votes are as a result of a faithless elector. And just giving you a very entertaining fact, the election that had the most faithless electors was back in the 1800s, where 66 electors were committed to a gentleman who died in between the election and the voting of the Electoral College. So technically all 66 of those votes, which eventually went to other parties, were faithless electors because they could not vote for the dead gentleman. So, what did the court actually find on this particular issue? The court held that the imposition of restrictions upon an elector is perfectly fine under the Constitution. Basing it off of the requirements or the uncontested requirements that an elector can be required to be a member of a state, or an elector can be required to meet other conditions, be of voting age, things of that nature. The court held that there was no issue constitutionally speaking with stating that there would be either a voiding of a elector's ballot or a punishment or fine imposed upon that ballot. That is perfectly fine constitutionally speaking. So again, just a basic restraint or a basic restriction upon that type of voting. So I know we're at the very, very extreme of the time. I just wanted to mention to everyone that we do have some great webinars coming up as a part of this series. Next week, we'll be discussing a more practical topic, I suppose. We'll be looking at some of the tools that you can use for practice management and legal research in conjunction, investigating the relationship between FastCase and Clio practice management. The following week, we're going to do our second in our Leaders in Law symposiums, and we'll be discussing a number of great cases and legal traditions with Judge Thelton Henderson and all of the wonderful cases that he has been a part of. So I do recommend checking your email and joining us for those future sessions. I hope everyone had a great session today. We will be sending out our slides and a link to today's recording via email to all people who have registered for today's session. So I hope you had a great time and that you'll join us for our future sessions.